Welcome to the Flex Your Rights podcast. I'm your host, Corey Hanrahan. This is the podcast for informing employees of their rights in California. So if you want to know your rights so that you can flex them at work, this is your show. Let's get flexing.
All right, everyone, welcome back to the Flex Your Rights podcast. You've got me, attorney Corey Hanrahan again, here with my good friend Travis Triggs. And we've got a little special show today talking about sort of a big issue in the workplace.
Yes.
Discrimination.
Yes. That's a big thing. Starting off the year too, I think this is a subject that I think people would be interested in learning, especially for 2024. It's a new year. And if you've been dealing with something all last year, you don't want to go into this new year having the same issues. So hopefully the information that we can give you, Corey's going to go over some things into detail with work discrimination, and hopefully this can bring you a tremendous value and give you a lot more confidence going into work every single day.
Right. It's all about making sure that you're protecting your rights at work. Travis has some questions for me. We'll do question and answer. I think he's compiled a list of common questions that people have about discrimination cases so that I can hopefully enlighten everybody on what your rights are, what to look out for, and make sure that you're not being subjected to unlawful discrimination in the workplace.
Exactly.
So let's get to it. I know we're going to run over on time because Travis and I always talk for a while. So let's jump right into it. Travis, hit me with the questions and let's educate everyone.
All right, perfect. And I just want to throw it out too. I'll throw it out there as well too. If you guys want to reach out to Corey Hanrahan, you can reach out to him. What's your email again, Corey? You just say it so someone's listening.
Right. So it's Corey@hanrahanfirm.com. You can find me on basically all the socials. The handle is usually at Attorney Corey, Corey. Corey. So I'm Corey with an E in there, Corey. But I'm easy to find online. If you want to reach out, happy to chat with you.
Awesome. Well, let's get it, guys. So one of the first questions I have here for Corey regarding work discrimination is, how is it legally characterized? How is work discrimination legally characterized under California law?
Okay, good question. So I think everybody sort of knows what discrimination is, right? It's a differential treatment. So it's treating a person or a group of people differently than another group of people, right? So in order to be unlawful, though, under California law, it has to be based on a protected characteristic. So that means a difference in treatment based on age, race, sex, gender, national origin, medical condition, physical disability. One of those things under the Fair Employment Housing Act, right? And they're enumerated in the Fair Employment Housing Act. So you can go there and look at it. It's California Government Code Section 12940. And those lay out the bases upon which people cannot be treated differently in the workplace, right? So certain groups of people cannot be given privileges that other groups can't. And if something is not listed in the Fair Employment Housing Act as a basis for not being able to treat someone differently, then it means that the employer can do it. So I listed off a couple, right, Travis? One thing I did not list off was friends, because I get a lot of calls where there's favoritism in the workplace, right? Of
course.
So supervisor is giving all the overtime hours to his friend. They went to high school together, yada, yada, yada. And so he's playing favorites. That in a sense is discrimination, right? It's treating somebody differently than another, but the status of, friendship or favoritism or nepotism in the workplace is not illegal. So that would not support a discrimination claim if the supervisor is playing favorites. Now, if the supervisor is playing favorites based on race, right, or based on sex, something like that, then that could be actionable. But the key is determining whether or not the basis is one of those things listed in the Fair Employment Housing Act. That's the key.
Oh my gosh. Oh, wow. That's interesting. See, I can see someone saying that too in regards to that for discrimination with their friends. Like, hey man, I've been here for 5 years. They just brought them in and they're getting that position sooner than me. And I've been putting in my blood and sweat into this place. So is there would that be considered something, or is that just, hey man, this is time for you to look for a different job?
Well, I mean, look, it always depends on the circumstances, right? Mm-hmm. Lawyers never like to give you a yes or no. It's always, well, it depends, but it really does, right? I mean, if their friend came in and they wanted to promote, that person because they don't like people of a different race and all the other employees were of the other race and they didn't want to promote, then there may be something there, right? Okay. But again, in order for there to be something, you have to be able to show that whatever the protected characteristic is, age, race, sex, gender, national origin, all those things, you have to be able to prove in court that it is a substantial motivating factor for the reason why the employer did what it did.
Wow.
And so you've got to be able to tie it to one of those things. Favoritism, nepotism, no.
That's
They
not
just
discrimination.
don't get you there. Yeah, that's not unlawful.
Oh wow. Okay. And that kind of leads into my next question too. What are the different types of discrimination that occur in the workplace?
Man, I think I just went through them. I mean,
I
it's,
know.
again,
Yes.
age, race, sex, national origin, medical condition, uh, veteran status, religion, any of those things. Now, conceptually, right, discrimination can take a lot of different, or can look like a lot of different things. And,
Hmm.
maybe we'll talk about this later. I don't know what questions you've got lined up for me, but, it can be the denial of benefits. You know what I mean? So the
Oh
denial
wow.
of being able to work overtime. You know what I mean? It could be, a demotion. It could be termination. So, there are a lot of different sort of adverse employment actions that can take place to trigger a discrimination claim.
Okay.
But again, the question is going to be, though, right? Is the mistreatment based on one of those protected characteristics that the law says, look, employers, you can't do this?
Yeah, it's
You know
just
what I mean? You
wrong.
can't make decisions based on this characteristic. And that's what you've got to be able to prove to even have the hope of having, a valid discrimination claim.
Okay. Thank you. I hope this is making sense to you guys listening right now. Um, and so the next question I have here is, really just recognizing discrimination. How can an employee recognize if they're being discriminated against?
I I mean, that's tough. I mean, I would say the main thing is just, having the feeling that you're being treated differently than others. You know what I mean? The feeling like, look, I'm not getting the same, privileges at my job as these other people. Right? I'm not getting the same ability to be able to work overtime. I'm not being given, what I mean, the same pay. Sometimes there's a pay discrepancy, right? Where men will make significantly more than women make for performing the same job.
Yeah.
So it's really just, the am I being treated differently than others at work? You know what I mean? That sort of a thing. And if so, then trying to figure out what the basis for that differential treatment is. And sometimes it comes down to performance. You know what I mean? A lot of times the employer will say, well, we're treating this person better because they're a better
The
worker.
performer. Yeah.
So and so is having performance issues that, you know what I mean? They're not doing a good job. We had to put them on a performance improvement plan. And so that'll sometimes be the justification or the defense from the employer is this person's just a better worker. You know what I mean? We value that. But that's something that a lawyer has to take a look at and go, is there any evidence of that? You know what I mean? Is there any support for that being the reason? Or is it, based on a protected characteristic?
Okay. And then like in those type of situations, it's a question actually further down, but since we're like in in this specific conversation regarding that, when people are dealing with these issues, you've said this many times, and I think it's like ingrained in my head. They document and document and document when they're dealing with these issues. Do you think it's best to document for months? Or how much time do you think a person should be documenting before they feel they should reach out to an employment lawyer about the issues at work?
Well, I would say there's probably no period of time. I would say it's more based on severity. You know what I mean? So document everything. I mean, even after you've reached out and talked to an employment attorney, maybe keep documenting, because if it's still going on at work, right? The reason for documenting is so if you get engaged in litigation, and you're a plaintiff in a lawsuit suing your employer for discrimination, the documentation that you've prepared is what helps you recall what happened. Right. So, so you've got a list of things that happened, the days that it happened, who did it. You have those things at your disposal and you haven't forgotten what happened so that you
Yeah.
don't have to answer in deposition. I really don't know. I really don't know, when that happened. I couldn't tell you. Well, who was present when it happened? Who may have witnessed it? I don't remember who was there. I know we were out on the sales floor and I know there were other employees around, but I don't remember who they were. Right. So if you write those things down, you're going to remember it. And I'm a believer that contemporaneous notes like that, if you have documentation, if you have notes that you wrote down about what happened and you wrote them down at the time that it happened, is that there's sort of a built-in credibility to the jury.
I
You know what I mean?
see.
So if we can show at trial the jury those notes and put them up on a projector and say, these are the notes that you took after the
Sheesh.
incidents happened, correct? They're going to go, okay, yeah. I mean, I believe this happened. I
Yeah.
don't think he's making it up after the fact. His testimony is these are contemporaneous notes, and the other side isn't going to have any evidence that it's not.
Yeah.
They weren't
Yep.
there with you, when you wrote them. They're not going to have a basis to say that they're created after the fact. So it's
Yeah.
important, again, to document what happened so that you recall what happened. But I also think it builds credibility for the jury to show them the notes that were made immediately after the incidents happened.
Okay, so now I hope you guys are hearing this. If you know someone dealing with work discrimination or complaining about any of these type of issues that we're talking about, tell them to take notes and document, document, document. It's so important. I hope that
Very
this has
important.
become a value. This is good for me to even just to hear and sit stuck in my brain. And I hope for the listeners, this is making sense to you and it's giving you a little more confidence in knowing exactly how to deal with issues at work. Because years ago, I'm 40 years old. Years ago, I was having issues at work, and I probably had a case and had no idea until I started speaking with Corey and understanding how laws work. And I felt like I was probably discriminated against for being a man when I was back in my old job because she would promote all the women. She would give them bonuses. She would buy them lunch, and she would just like kind of like not do anything for me. And I hated it, and I ended up quitting. But it was like, if I would have been documenting exactly what she was doing, and I would have had so much more confidence after hearing something like this. So I hope this is empowering you guys just listening right now.
And look, Travis, this is about empowerment, right? This podcast is not a replacement for talking to a lawyer. I mean, it just isn't, because I could not tell you on a podcast, here are all the incidents, in which you have a claim for discrimination, and here's the one that you don't. It depends on the circumstances. You know what I mean? It is dependent on the circumstances, and it requires an analysis from an employment attorney to figure it out.
Yeah.
But the purpose of the podcast is empowerment. So
Yeah.
people know what their rights are, so that they know when it's time to go, man, maybe I should talk to a lawyer about this.
Yeah.
You know what I
Yep.
mean? Maybe I should reach out to Corey. Maybe I should reach out to a different employment attorney. It doesn't matter who it is. Reach out to someone.
Yes.
You know what I mean? That's the important part, to find out, do you have a case, and what should you be doing that you're not doing at the moment in order to
Exactly.
be able to address it at work? A lawyer can go, look, documentation is great. You've got the documentation, but have you let the employer know?
Yeah.
Did you talk to HR? You know what I mean? Because part of it too is letting the employer know, right? Because the employer has obligations and steps that they have to take when it's brought to their attention that there may be discrimination or harassment, retaliation, those sort of things. And so, juries expect you to give the employer an opportunity to fix it. You know what I mean? So if you just jump right to the lawsuit and you're like, let's go, that may not benefit you. If you haven't brought it to HR's attention and given them a chance to fix it, the jury may go, we don't really want to hold the employer responsible because we don't think that you gave them a chance to make it right. You seem litigious. You just jumped right into the lawsuit. So, putting the employer on notice or HR on notice so that they can do what they're supposed to do can be a great step in the process. And if HR screws it up, if HR doesn't do what they're supposed to do, doesn't talk to people, brushes it under the rug, that can be helpful for you in the lawsuit then, because it showed that you gave them the chance and that they failed you.
Man. And that's like a clear indication that they do not care.
Yeah,
That's a
sometimes they
clear
don't.
indication. Yeah.
Sometimes they just don't care.
Yeah.
It's sad, but it's true.
Yeah. So now we're leading into that. Like these questions are like the flow of the way you're answering these are perfect with the next question. So what's
I do
the
my best, Travis.
Oh, you do a great job every time. I hope you guys love the way that we are having this conversation right now. So the next question is, what is the process for filing a discrimination claim in San Diego?
Okay. Step one is usually hire a lawyer. You know what I mean? Or at least, reach out to lawyers and talk to them. You know what I mean? Like, because if you hire a lawyer, if somebody hires me, I take care of every step. of the litigation process, right? So that starts with filing a complaint with what used to be the Department of Fair Employment and Housing, the DFEH, and people still call it that. It went through a name change. I think it was last year to the California Civil Rights Department, but they oversee the same stuff. But you have to file a complaint with them and get a right to sue to file your lawsuit in the courthouse within 3 years of the bad act happening. So it used to be 1, they extended it to 3 a couple years ago. So you have 3 years to do that. If you don't do that and you just file your lawsuit down at the courthouse, it's going to get dismissed. So that is a prerequisite to being able to file that claim. So when somebody hires me, I file that, I get the right to sue. We're off to the races. We can file the lawsuit in court. But the Civil Rights Department also will take your complaint. If you have a complaint as an employee and you don't want to hire a lawyer or there's no lawyer interested in the case, you can file a complaint with the Civil Rights Department yourself. And, they sort of, will gather information from the other side. They'll get the employer's, version of what's happening. They can get documents for you. Sometimes they'll hold a mediation to see if they can help get the situation resolved. So they will take steps for you, but I don't mess with that. If somebody's hired me to represent them, I get the right to sue from the Civil Rights Department and just file the lawsuit down at the courthouse.
Wow. Okay. If people were trying to find, you said the Civil Rights Department, Employment Department, is that the proper name or?
Just the Civil Rights Department. So California Civil Rights Department.
Okay. I hope you guys write that down. Civil Rights California Department. Is that correct?
California Civil Rights Department.
California Civil Rights Department.
There we go, Travis. There we go. I know. It's a lot of words.
It's like a tongue twister.
Yeah, and it's called a right to sue. So there are 2 options if you get to their website and you want to file a right to sue. There's a right to sue where they actually will look into, the situation for you, and then there's a complaint with an immediate right to sue, which is what I file as the lawyer. I go, look, I don't need you guys looking into it. I just need the piece of paper that says we're clear to file the lawsuit down at the courthouse so that we can file it. So if you're filing it yourself and you do not have a lawyer, you probably want to make sure you're choosing the option to file the complaint or charge of discrimination with them and have them look into it. Do not get the immediate right to sue because you will get no help from them. If you do, it's really an auto-generated PDF file that gets emailed to you immediately after you click submit.
Okay. This is some great information. Okay. And then really quick too, does the process for doing that different from the state to the federal levels? Is there a difference?
There is. So federal has the EEOC, right? And we have the CRD. So they do the same thing. If you needed to sue under federal law, though, you've got to get that right to sue from the EEOC. So you've got to get it from them.
EEOC.
Now, there are not a lot of reasons, if you're a California employee, that you would, in my opinion, that you would want to do that, though. Right? I mean, the laws sort of track each other, but there are small nuances in the law where California law is generally more protective and more employee friendly than federal law.
Okay.
So you've got to be careful about that because I get people that are like, well, I'm just going to go to the EEOC because that's the name they think of, right? The EEOC. And I tell them, I'm like, look, you can go and file a complaint with whoever you want, but be careful. I mean, you may want to do it with the Civil Rights Department, California Civil Rights Department, or you can do it jointly. You know what I mean? You can file it with both of them sort of simultaneously. I think with, you can check a box with the EEOC that says I want it filed with the Civil Rights Department, at the same time that this is filed. But because if you get a right to sue from the EEOC, that's going to cover federal law, not necessarily state law. So, you may then have, precluded yourself from being able to sue under state law, and you may be forced to pursue it under federal law, which again, sometimes is not as protective as state law.
Okay. Oh, wow. That makes complete sense too, because the state's protecting the people of that state specifically versus the federal is protecting the whole country.
Yeah. So federal goes, look, we're the United States of America. We want people treated right. So here are the rules under federal law, right? Here are the rules. And then the states cannot protect less, right? federal law sets like the baseline of what's protected, but then states like California can come forward and go, but we're also going to protect this.
Oh,
You
that's
know what I mean?
awesome.
But we're also going to protect that. I think it was a while ago, sexual orientation was not protected, right, under federal law. And California was like, well, we're going to do it.
Oh, wow.
We're going to make that part of the protected characteristic. So, they can take federal law and they can sort of, pump it up a little bit, make
That's
it more
cool.
protected.
That is actually very cool. Let's see. And then this one we have here. Let's see. Oh, yeah. Is mental health and people having mental health issues, could something in that regard be considered a work discrimination if they feel like they're being discriminated for what's going on them personally, mentally?
Yeah. Yeah. So when it comes to disability discrimination, there's physical and there's mental. So mental disabilities are protected the same as a physical disability. So somebody dealing with depression, anxiety, PTSD, they have the same rights as somebody dealing with a broken leg.
Oh,
You know what I
wow.
mean? Or like a fractured back or whatever it might be. So you have the same protections, which means the employer has the same obligations to provide accommodations if you need them. You have the same protections for medical leave, to take leave to deal with that mental health issue. So you do. I mean, they are the same rights as if it was a physical disability. It's just that you're dealing with with the mental issue, but you're entitled to certain things to make sure that you have the ability to take care of it.
Oh, that's cool. Okay, perfect. And then I think you pretty much got me wrapped up here. Let's see. Uh Corey, I think you done.
I got you
I,
speechless, man.
Yeah, man. I mean, I had a handful of questions, and I think the way you were answering all of them, you went into detail to so many things. It's like you ran into other questions, so I'll just be repeating myself.
Perfect.
but what?
Perfect.
But I hope you guys were entertained and learned something here. And I also hope if you guys do have any questions, to reach out to Corey Hanrahan, attorney Corey. Is that correct for your link for social media?
That's my link for social media. You can also go to attorneycorey.com and that'll navigate you. That'll direct you to my law firm website. So that will send you to hanrahanfirm.com, which you can also directly go to. But either way, I'm easy to find, easy to talk to, always willing to chat with people having problems.
All right, perfect. And then if you guys have any questions, reach out to Corey. We'll get back to you and we'll make a part 2 of this, just to go over any additional questions you guys may have while listening to this podcast. Thank you guys so much for tapping in with us today.
Hey, thanks for joining, everybody. We had a good time, Travis. As always, man, I appreciate it. Remember to know your rights at work so you can flex your rights at work and make sure that you're not being taken advantage of. Take care, all.
Let's go.
Thank you for listening to Flex Your Rights Podcast, the podcast to educate California employees so that they can flex their rights in the workplace. If you'd like to reach out to me to ask me any questions about today's episode or make a suggestion for a future episode, you can find me at attorneycorey.com. That's attorneycorey, COREY.com.